Call the meeting in order. Good evening, everyone, and welcome to the February 7, 2024 City of Fraser Regular Planning Commission meeting. Please place any cell phones or any other devices that might disrupt this meeting in silent mode or turn them off. Please join us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Agenda item 2 is the roll call. Ms. Warren, would you please do the roll call?
Yes. Commissioner Barr?
Present.
Commissioner Farina?
Present.
Commissioner Kyle?
Present.
Commissioner Meyer?
Present.
Commissioner Warnick?
Present.
And Chair Zarnicki?
Present. Quorum's present. Agenda item number 2 is approval of the agenda. Is there any discussion as the agenda is printed?
Nope.
No, I'll take a motion to approve the agenda as.
I move to approve the agenda as presented.
I'll second.
Okay, it's been moved by Commissioner Farina and support by Commissioner Kyle to approve the agenda as presented. Roll call, please, Ms. Warren.
Commissioner Barr?
Yes.
Commissioner Farina?
Yes.
Commissioner Kyle?
Yes.
Commissioner Meyer?
Yes.
Commissioner Warnick?
Yes.
And Chair Zarnicki?
Yes. Okay, motion is carried unanimously. Agenda item number 4 is the chairperson's opening remarks. Tonight's meeting will follow the agenda that was posted online and has been printed for you here and is available at the entrance to the room. It is important to let everyone know the Planning Commission is created by state law. The commission is comprised of 7 members, all of whom have volunteered to serve. Members are appointed by the mayor and confirmed by City Council. Let's note this evening we do have a board vacancy, so there are 6 present members this evening. The role of the Planning Commission is to plan and promote the efficient, coordinated development of the city for the health, safety, and general welfare of its residents. We are not here to negotiate with applicants or allow everything an applicant is requesting. However, the Planning Commission does have the power to approve certain requests and recommend others, depending on the nature of the request and whether all of the standards in the zoning ordinance have been met. The Planning Commission may also impose conditions on a proposed project in order to ensure that those standards are met. Other individuals seated here this evening are the city's legal representative from O'Reilly, Rancilio PC, Alyssa Erickson, also Lauren Sayre and Alicia Warren from McKenna and Associates, and that's all we have here this evening, correct? Okay. We do not have any public hearings scheduled this evening, so I will forego those comments, and we'll go to agenda item number 5, approval of the minutes, January 3, 2024. Any discussion on the minutes? None. I have a few corrections. Anybody else have any? No? Okay. They're very minor corrections. On page 2, under item, well, all of the corrections are under item number 6B. Page 2, paragraph beginning with the Mr. Gaber, with this remarks, correct the public parking at the site. We were, actually, the question posed was the public park, not the parking. On page 3, it's going to be the 4th paragraph beginning with Attorney Tomish. It is the 3rd sentence, the conditions must be imposed by the applicant. I believe a better way of phrasing that is offered. And then on page 4, under the public hearing, the first speaker, Mr. Greg Gruneberg, sorry if I mispronounce his name, he is speaking about the Canadian geese. Just correct the spelling of geese. And that's all I have. And if there's no further discussion,
I missed your second correction.
the second one was on page 4, on page 3, under the remarks by Attorney Tomish. The conditions must be imposed by the applicant. Should be offered a better way of phrasing that. Okay. Any questions on my comments?
Make a motion to approve with the amendments. I'll support.
Okay, it's been moved by Commissioner Warnick and support by Commissioner Kyle to approve the So January 3, 2024 draft minutes with the corrections as presented. Ms. Warren, would you do a roll call, please?
Commissioner Barr,
Yes.
Commissioner Farina,
Yes.
Commissioner Kyle,
Yes.
Commissioner Meyer,
Yes.
Commissioner Warnick,
Yes.
Chair Zarnicki.
Yes. Motion carries unanimously. Agenda item 6, new business of the board, the 2023 annual report and zoning report, and the 2024 annual work plan. Ms. Sarah, do you want to do any presentation on this?
I can introduce it a little bit. So this, I'm sure as many of you are familiar with, is a requirement of the Michigan Planning Enabling Act for the Planning Commission to report to City Council its activities for the year. We also include our zoning board in that, and we combine it. So this year, we added the zoning board members as well to show recognition, because we do appreciate what they do on that board. We also added some zoning administration items so that the City Council can also see the day-to-day activities. And then I think the most important is the 2024 work plan, and I got some feedback from several of you on different projects that we might want to accomplish in this upcoming year. So if anyone has any other additional thoughts or tweaks to it before we submit it to City Council, it's still has to go through the zoning board, and they'll see it at their next March meeting. But I think that's the summary, if anyone has any comments or discussion on it.
Okay. Any comments, discussion on the item? Do we make a motion, or do we make a motion to forward it to City Council?
Yes,
The review of ZBA meeting.
yeah, I mean, that would be perfect, yep. But there is a motion to forward to City Council. That would be necessary.
Okay, I'll entertain a motion then.
I move to forward the 2023 Planning Commission and Zoning Board of Appeals report to the City Council for the Planning Commission.
Support.
Okay, it's been moved by Commissioner Farina and support by Commissioner Kyle to forward the 2023 annual planning and zoning report to City Council. I would just add after the ZBA review of that item. And any comments on that motion? Okay, and Ms. Warren, would you do a roll call, please?
Commissioner Barr,
Yes.
Commissioner Farina,
Yes.
Commissioner Kyle,
Yes.
Commissioner Meyer,
Yes.
Commissioner Warnick,
Yes.
Chair Zarnicki.
Yes. Motion carries unanimously. Agenda item 7 is the unfinished business sign ordinance discussion. Ms. Sarah, are you doing that?
Yep. Okay. So, you all recall, we pushed January's discussion off. It wasn't too lengthy, so this shouldn't add too much extra time. So we'll be talking about non-conforming signage today, as well as billboards, real estate development signage, and residential subdivision identification signs. Just looking ahead, we are still targeting a May or June recommendation to City Council, potential adoption. So our last scheduled discussion will be April 3rd. So we've got a couple more months, but I appreciate everyone's patience and feedback as we work through this. So regarding the ordinance language from December 6th, the December 6th meeting, I know Chair Zarnicki had a comment on number 2 on enforcement. Looks like we missed changing on the fourth line within 24 hours rather than 4, so we'll make that change. That's noted. Is there anything else for discussion on the December ordinance language?
Ms. Sarah, I'm going to ask a question. I think you and I talked about it before our January meeting, was the home occupation signs. I think we were supposed to follow up on that, and I apologize, I didn't remind you before the meeting.
Yeah, so I believe there is, on page 4 of that memo, under number 7, in the parentheses and italics. So regarding home occupation signage, so the ordinance currently allows 1 non-illuminated nameplate, and the limit for the area is 2 square feet. So looking at peer communities, Roseville does not allow signage for home occupations. Warren allows one non-illuminated nameplate. Their limit is 1 square foot in area, and then East Point also does not allow signage for home occupations.
Okay.
I guess, given that, is there a more clear direction the planning commission would like for that signage?
Any members have any comments on that? I thought 2 square feet was big. That was just my thought. To go down to maybe 1 square foot. Any discussion? Little, 1 square foot's little?
Yes.
This is going on a resident,
Yes,
though.
yeah. But viewable from the street
Okay.
should be. I mean, it was always 2. For all the time I was,
I'm open to any remarks. That was just my thought.
and the only other one was Warren that you said?
Some of them don't fit at all.
Regarding,
That,
from the couple that, yeah, the couple
Yeah.
surrounding.
The other ones don't even allow.
They don't allow it, no.
So do we know the square footage that Warren says?
1,
Oh, it does say 1?
yeah, 1 square foot.
So we can do that. I mean,
Why don't we
you,
do 1?
you pull in to the driveway, and that's where they're gonna see that
Right.
they're at the right place. That's all it is for.
It's just to say, hey.
It's not to advertise,
Right.
so 1 square foot they even would work still.
Trying to think what mine is.
12 by 12 or 6 by
Yeah.
6 by 2.
Yeah.
You know, 6 inches by 2 feet.
Yeah, 1 square.
And that's probably what most would be. I would say this going wider to get a whole name and maybe an occupation.
Do we have a consensus on changing it to 1 square feet? Or do we need a roll call on that, or just, yeah, just discussion?
I'm for it. Fine with me.
Hands up, change it to 1 square feet? We have
Yeah.
a consensus, Joanne? Are you okay with that? Yeah. Okay, all right. Thank you, Ms. Sayre.
We'll note that, thank you.
All right, ready to go forward.
Okay. All right, we'll start with the nonconformities then. So we've got 7 recommendations to walk through. The first one is, notwithstanding any other provisions of this ordinance, signs lawfully in existence on the date the provisions of the ordinance enacting this section were first advertised, which do not conform to the provisions of this section, but which are in compliance with the applicable regulations at the time they were constructed, erected, installed, affixed, or maintained, shall be regarded as nonconforming. However, a sign installed during the period following the day on which the Supreme Court released its opinion on Reed v. the Town of Gilbert, and the date the provisions of the section were first advertised for adoption, shall be considered a nonconforming sign unless it's conformed to the regulations in effect on the day immediately preceding the release of the decision of Reed v. Town of Gilbert. A little lengthy. Does anyone have any comments on that? It's addressing the nonconformity aspect of signage.
I think.
I'm just thinking about what we went over at our last meeting. What, how do you decide the nonconformity? What do you consider remember you considered part of the sign this way, and when we looked at it, we considered the part of the sign that way.
Yeah, and truthfully, that section of the ordinance that was the sign area is actually in the definition section, so it's not under the sign, but that might be something to update in addition when we do
Okay.
redo chapter
All right,
32.
good.
Sounds like the only problem would be who's going to decide? Who's going to go around and check every existing sign that it's non-conforming
Well,
previously? You know,
Didn't we talk
and
about?
keep a record of it.
Can you do that, though?
Yeah,
I mean, it's already been approved.
I mean, it might be a long-term project where the code enforcement guy goes out
Yeah,
twice a month and
just
looks at.
concentrates on signs.
Yeah, starts at one end of the city and goes to the other end,
I think it was part of our discussion prior to this is, kind of feedback from the city attorney or peer communities on how to conduct sign inspections. or if we conduct sign inspections. I think we kind of talked on that subject a little bit, but didn't, we're waiting for a little bit of feedback, I think.
I think we were too.
Yeah, I think, yeah. Another little, I apologize, I should have reminded you also, Ms. Sarah, about that. But I think we did say, how do we do sign inspections, and who does them, and how regular are the inspections?
Yeah, I don't think I have a clear answer currently,
Okay,
but
that's fine.
but we can follow up the next
Right.
one and
Okay.
have a more comprehensive.
Okay, thank
report
you.
for you.
Excuse me,
Go ahead.
are you proposing that they check all the businesses that are already
Right,
in
come closer
Fraser
to your mic a little
and
bit,
make them
Joanne.
change their signs?
Yeah. Joanne, come
Joanne.
closer to the mic so we can all hear you.
Are you proposing that all the businesses in Fraser are checked? Somebody's going to go around and check them and make them change their signs if they don't conform?
I think the board was talking about how to, what's the word? Schedule inspections regularly, and also potentially a code enforcement audit of signage in the city. So, does that didn't quite answer your question, did it?
I think what I'm concerned about, if a business has been here 10 years and suddenly they're told, no, you got to spend a lot of money, you got to pull this down, that's not very friendly to businesses.
So if it was in compliance at the time that it was erected, then it would be okay to stay. But this would be more looking at signs that were erected and they weren't in compliance either at the time or at this current time when this ordinance gets adopted.
I still think we have to be a little careful so Fraser doesn't get the reputation of being anti-business. And people will start moving out and not coming in. Coming in, they can comply, but if they've been here for years, I remember when they raised the water rates and the laundromat said they're closing up and leaving. They couldn't make a living here, so we lost that business.
Yeah, I don't think that's the intent.
Not the intent to scare people away, by all means,
Well,
no.
that's what I'm hoping. I'm hoping that this isn't going to be so strict that they're going to go around and say, aha, that business has been here, but they don't comply. We're going to make them change it.
I don't think that's the intent, is to change it. All the previous signs are going to be grandfathered in. I think it's, going forward and double, with the time that we can give of a code enforcement officer can be assigned, it's going to be a long-term assignment anyways, to go out and check the signs. But it's a good practice, I think.
As long as it's going to be grandfathered in, what they have now, and this is for the future, then I agree.
Okay.
But if their sign goes into disrepair,
Correct.
it must be
They have to
maintained.
change it. Okay,
Yes.
I understand that. That's okay.
Any type of maintenance.
Okay,
Okay, you're okay, Joanne?
I'm okay with that.
Okay, all right.
All right.
Go ahead.
Number 2, a non-conforming sign shall not be enlarged or extended. Number 3, a non-conforming sign shall not be moved to another location on the same lot or to any other lot. Number 4, a non-conforming sign that is destroyed or damaged as a result of factors beyond the control of the owner of the sign and the owner of the premise on which the sign is located, to an extent the destruction or damage exceeds 50% of its appraised value, shall not be replaced or restored unless it complies with this section. Any questions on these items? All right. Number 5, a non-conforming sign that is destroyed or damaged as a result of factors beyond the control of the owner of the sign and the owner of the premise on which the sign is located, to an extent that the destruction or damage is 50% or less of the appraised value, may be replaced or restored, provided that the replacement or restoration is completed within 6 months after the date of the destruction or damage, and the sign is not enlarged or extended. The time for replacement or restoration may be extended for one additional 6-month period if the building department verifies that the replacement and/or restoration process is underway, is being pursued in good faith, and delays in the process are reasonably related to insurance and other financing delays beyond the control of the owner of the sign. Any comments on this provision?
Why would it just be What if there's a parts delay? I mean, shouldn't it be just if there's a delay beyond the control of the owner of the sign?
I think that'd be a reasonable change.
You would think most people wouldn't let it get that. They're there to promote their business, and you'd think they'd want to get it done as quick
Yep.
as possible. But we're using 6 months then as a time period if they don't do something. That's being pretty generous.
It also states if the process is underway and the owner is in good faith, that
Right.
it can be delayed again, I guess. I don't know if that's phrased that way. Delays of process are reasonably related to insurance or other financing delays. Maybe we could say, how do you want to phrase it with not having the supplies in hand?
I think she's adding.
Or other
You're adding
delays?
that,
Just,
okay.
you just cut out the word insurance or other delays.
Okay.
I would say it still comes to communication. If they would communicate with the building department or whatever, whoever's going to patrol it. Communication is the big thing, and they say, hey, we're working on this, and it's back to being pursued in good faith, and that, the funds aren't available right now. It's the worst time of their season, maybe. No revenue coming in. I mean, there's all kind of excuses or reasons. So I would say as long as communication is between the building department and them, and they're not trying to avoid it.
Or maybe even other acceptable extenuating circumstances, something like that. Kind of include everything. We trust you with the wording.
We'll rework it and then revisit it next month.
Okay.
All right, number 6, a non-conforming sign declared to be unsafe by a code official because of the physical condition of the sign, including an unsafe physical condition arising from the failure of the sign to be maintained, shall be removed. And then finally, the owners of any premises on which there is installed a non-conforming sign shall, upon notice from the city planner, submit verification within 60 days that the sign was lawfully in existence at the time of adoption of these sign regulations. The city planner shall maintain a registry of such non-conforming signs.
Lauren, going back to the one before that. On 6.
Sorry.
A non-conforming sign declared to be unsafe by a code official shall be removed. By who?
It would be by the applicant, and I'm not sure, I think there was a provision, but it might be specific to that section where it specified that the applicant was responsible for any cost incurred. But I can double check that encompasses all of removal of signs, and if not, we can put that back in that section.
And what if the applicant says no?
Then they go to court. Is that?
Right? They go to court?
Right.
Right.
Not with our lawyers.
As long as we put it in there. We're trying to be as specific as we can, and that's a good thing, is include that.
Anything else on these?
Go to 7, though. The city planner shall maintain a registry of such non-conforming signs. I think we discussed that. Has there ever been a registry within the city?
There's not.
Do we create one, or how does that work, Ms. Sarah?
Mr. Logan mentioned, and this came up with the electronic message boards, he mentioned that it would be a good idea to create that and that he could start that, but I do not think it has been started yet.
It hasn't been activated.
No, but when we're talking, we're not just talking about electronic boards. We're talking about building signage, all signs,
All signs.
correct?
Yeah, to my knowledge, there is no current record of non-conformings.
So this has come up before with the registry by the city planner, because we don't really have any type of tracking system.
Not presently, no.
Do we still leave it in there, or do we? do away with the wording.
I thought we talked about we needed a way to enforce it, and I thought there was an action item given. It just eludes me right now.
Okay. Maybe kind of
Do the young
backtrack and
minds
find
think
out what the
about that?
registry on signs.
I will say, Madam Chair, I do think that this is, and if memory serves, I'm sorry, a lot of this runs together for me, but I think the other registry for electronic boards was more kind of uniform. It was more like applied to everyone that had an electronic message board. This would only be in instances, the way that I read it, would be if someone is essentially trying to say that their sign is non-conforming and tells the city that, and essentially the city planner would say, we need verification that this is actually non-conforming. That's the way that I read this provision.
Okay, all right.
So it's more of, then that way, if we're given the proper notification, the city, in turn, in theory, has a registration of the non-conforming signs. Does that make a little bit more sense? It's a little different, I think, than what the registration requirements were for the electronic message boards, which was anytime you're putting an electronic message board up, you have to provide X, Y, Z.
And I think it needs to be reworded.
Okay.
You know.
Yeah, kind of work it a little bit.
With that theory in mind, then, that
Yes.
if they're trying to essentially say, no, we can have this up, here's the proof, okay.
Anything else on nonconformity before we go move on to billboards? All right. Billboards. So we've got 6 recommendations for consideration. Number 1, billboards are freestanding off-premise signs. Number 2, City Council has determined that signs and billboards located on premises to which they do not specifically relate and which are designed to capture the attention of motorists and others utilizing public ways create a danger to public safety by distracting the attention of drivers from the roadway who, in some instances, may focus on the message being conveyed, the anticipated message to follow, and/or other function of a billboard visible while operating a motor vehicle. A number of national and international studies during the period of 2013 and 2021 have observed that driving irrelevant material may make it difficult to extract information that is necessary for safe driving. Advertising signs affect driver attention to the extent that road safety is compromised. Clear evidence of impaired driving performance became evident as drivers passed billboards at higher speeds and drivers glanced more at the time of a switch to a new message display than when a billboard is simply visible and stable. So I believe these are both providing just more context on billboards and how the ordinance views billboards. I know the ordinance does this other places. When it talks about certain uses, it gives a little bit more context. Is that a direction that the Planning Commission would want included in this section, or?
Under number 1, is billboards are freestanding off-premises signs?
Yes.
Okay.
A lot of times, they're not even businesses in the city that are using those. They're
Got it.
advertising.
Okay.
So I like the idea that you take let's take one, for example, on M59 in Utica, right at Jimmy John's. I mean, there's a gigantic sign that keeps changing, and people want to read that message, all of a sudden it changes, and then they're looking at it again for the next message, and of course, traffic backs up during some hours of the day like that, and it's a great advertising for those people, I'm sure, but to me, it's a danger for driving. I mean, you're constantly looking. I do it at the college, at Macomb County Community College, because they're always putting events on there, and I'm sitting there going on the light on Garfield at Hall, and it's like they keep changing it, so I keep doing this with my head to see what's the next one or something. I don't think that's good. But in this city, we have very few, but we have Groesbeck, and Groesbeck has that. So what do you do with existing ones that, I mean, they're there, and they're gonna have, I think the biggest one are the technology advancing and putting things that they can keep changing it. Usually when it's one sign, it's there, you see it every day, and maybe it changes once, I don't know, they do it monthly, so it could change monthly, it could change every 6 months. That's different, but when you got this technology now with constant changing, and it's almost like us, you know, doing, like we're talking about electronic signs for businesses. This is being a off-premise sign, it's still advertising a business usually.
Yeah, so number 6 will actually address non-conforming billboards, which probably covers the ones on gross spec. I think we've got a couple more kind of context on billboards to consider for the direction that this commission wants to take on billboards. All right, jump to 3. So further, the U.S. Supreme Court has recognized that it is not speculative to recognize that billboards, by their very nature, wherever located and however constructed, can be perceived as an aesthetic harm. An unmarred landscape promotes tourism, levels the playing field between local businesses and national chains. 4, so at least 4 states have completely banned billboards, and at least 2 other states have banned the construction of any new billboards. And then 5, therefore, because billboards are only one form of expression for messages that can be communicated in many other reasonable and alternative ways, billboards are not permitted in the City of Fraser except as may be permitted by any governmental entity not subject to city regulation or control, in which instances all city regulations not otherwise preempted shall still apply. If not preempted, such billboards shall not exceed 25 feet in height or 150 square feet in area and shall be subject to the city's sign permitting process. And then finally, non-conforming billboards in existence on the date of the subsection adopted may be maintained and repaired so as to continue the useful life of the sign. However, no features or characteristics of non-conforming billboards may be expanded, enlarged, or extended, and all the regulations in this section and in other sections of the city code shall be applicable, and applicable technical codes shall apply to the non-conforming and exempt billboards in order to minimize their negative secondary effects, preserve the character and repose of adjacent areas, protect property values, and reduce traffic and similar hazards caused by undue distractions. Is this, that's, any questions, comments, concerns?
We're banning them.
So-
City of Fraser bans, do we have billboards in Fraser? We do?
Along,
13-mile gross spec all the way
Okay, the
up.
gross specs, okay,
Yeah,
okay.
even some on 14-mile, right by the railroad tracks, and
That's right. Masonic, too.
Masonic too.
Yep.
Yeah, yeah.
Okay, goes to show you how observant I am, okay.
so
Go ahead.
are you saying this is what we want to present to the city?
That's,
Or you're saying they have already done this and we're putting it into our new signage?
I believe, correct me if I'm wrong, that city council has addressed this.
I don't know that.
Is that not?
I thought that the current ordinance was silent on billboards, which is one of the reasons why we were just offering these as suggestions, because I don't think we have anything currently in the ordinance right now, is my belief.
Good.
We
And
used to-
I don't have a problem with that.
They used to have to come to planning commission if they wanted to put a new one up, and we would have to go through the permit process in the building department. And so that was the process previously from the, I know from the 1970s, 80s, and 90s. But I don't know of any additional billboards that came. I remember a big one in the 90s. And it went through the whole process, but those were the last ones, so what's there has been there for a while.
I'll make a note just to double check and cross-reference, of course, like we're doing with all these other provisions, but I will definitely double check with that.
Right. I mean, because under 2, it does say existing ordinance is silent, so we would want to put language into the ordinance.
Correct, yeah.
Right.
That's my belief.
Yeah. So, yeah. Any other discussion? Okay, Ms. Sierra, go ahead.
So then we'll move on to real estate development signage. And so this is referencing, it's not really referencing, like a single-family, like, home for sale sign. Those will be discussed, I think, more in the temporary signs next month.
Is that 24? Page
Yeah.
24.
We're trying to catch up with you here, Ms. Sierra, sorry. We're on page
worries.
24.
Yep, 24, number 6, real estate development signage. Again, real quick, so this is not covering like a single-family for sale sign. Those will be covered next month under temporary signs. And I will forward, we received a email memo from a realtor association regarding temporary for sale signs, and I'll forward that to the commission after tonight's meeting. So we've got 3 considerations. The first being 1 two-sided sign or 2 one-sided signs shall be permitted to be located at each entrance to the development, which is located on a major or secondary thoroughfare as identified upon the master road plan. In addition, 1 two-sided sign shall be permitted to be located upon a boulevard median of a collector, local, or private street leading directly to the development. Number 2, signs permitted under this subsection shall not exceed a maximum of 25 square feet. And all other provisions of this section not in conflict with this subsection shall apply. So,
How long can that sign be up? Should there be a time limit on that?
I think there should, and it would probably be contingent on when the development is finished, but we can add language for a time frame.
Good catch there, Frank.
It could really extend, because you got neighborhoods, subdivisions that are being built, and then they got 3 lots left, and that's it, they're done. And then they sell those lots, but you could always say, well, it's still under construction if they're gonna develop those. So it becomes one of those fine-tuning things. Maybe we need to just add a little thing for so many months of inactivity.
Or after a year, they must come back
Or, yeah.
for reapproval.
Okay, we can workshop that and come back with some draft language for a time frame on these.
Okay.
Any other items? All right. So last up, we've got residential subdivision identification signs, and we've got 6 items on this. First, shall not exceed a maximum of 25 square feet per sign. Shall be permitted to be located either upon masonry walls along the perimeter of the development meeting the requirements of this ordinance, or upon masonry entranceway structure meeting the requirements of this ordinance.
So we're really talking about a monument there.
I think it's more like a sign put on some complexes have, or subdivisions have walls that kind of almost
They
frame it.
come, I've seen wraparounds, and they can be, I understand that, the one above it, but
So I think these are talking about that it's allowable to put signs upon those structures.
okay.
So I guess it would be a monument type. It's more of a wall sign on a masonry, but in essence, it does become like
That's
a
all.
monument.
It's the design of the subdivision. If they put a masonry wall like both sides, let's take the entrance, and you're talking about medians here and that, and we talk about being in the median, that's coming up. But those are on the sides, maybe of 2 parcels. So those people actually have a masonry, a brick wall, short one, maybe at angles, maybe it does, it's hard to say, but they put them on the face of that to name, for the name of the subdivision.
But if it's on an island,
That's the difference.
that should be designated as a monument type sign in my. Rather, I don't want to see a freestanding sign there.
No, we definitely have to have height limits, and I thought that was in here.
I think it might have.
Yeah, in the, we got the square footage, 24 square
24
feet.
square feet.
So we
I thought there was a height somewhere in here.
So we do talk about it from the December 6th meeting
Yeah,
Isn't that
under
freestanding
freestanding.
signs?
Yep, correct.
Yeah.
Commissioner Meyer.
Right.
Yeah.
But
There's on the back.
'cause you don't want blocking vision, especially if it's in a median between
Right.
two different directions and that.
So there are clear vision triangle sight distance that would prohibit anything that might impede vision. However, I believe we currently allow up to 6 feet in the residential districts for subdivision identification. Is that something that we want lowered?
6 feet's kind of high for a car. You got to think about somebody driving in a car, and if it's a small car. I mean, we got to take into consideration whatever height. It could be a van and they're up higher, and 6 feet might be okay, or a truck, but a small little car.
4?
Yeah, I think 4 foot's about the max.
yeah, I would think.
Yep.
All right, we'll change that in that section. So one two-sided sign or two one-sided sign shall be permitted to be located at each entrance to the development, which is located on a major or secondary thoroughfare as identified upon the master road plan. In addition, one two-sided sign shall be permitted to be located upon a boulevard, median of a collector, local, or private street leading directly into the development. The residential subdivision identification sign structure shall be in scale with any adjoining landscape treatment.
Residential identification sign shall be in, but can be no larger than 25 square feet. Is that correct?
Correct.
And no higher again. And because you're talking about the adjoining landscape treatment,
Right.
could be something higher, so we still got to keep that limit, not to the height of the landscape, to our maximum height.
So we're changing this provision under 4 to be more of a concrete 4 feet rather than, although I guess if it's, we'll workshop it because then I guess if it's on a masonry wall, it might be a little higher.
So many
but
different
any-
situations. Yeah,
If it's on a masonry wall, it's not going to be protruding out, it's going to be back.
Right, right.
Yeah, that would be a little different. And I
Well-
would think that could be up 6 feet if it's on a masonry wall.
Right.
You know, like if it's on walls that you go into sub,
right. And it's not, no vision obstruction to anything. It actually gives privacy to the people there with lights coming in. So it's probably not a bad idea in some cases to have that.
Okay, we can draft some more concrete
Yeah.
language instead of the landscaping for the height and make sure that the different types of signs that are allowed are in consideration with that. So no entranceway sign structure permitted under this subsection shall be constructed of exposed concrete block, cinder block, precast concrete panels, or poured concrete. And any permitted residential subdivision identification sign shall be located in either a common area of the development or upon property for which a private easement has been granted to a subdivision association or similar entity, which shall have the responsibility for maintaining the sign and any appurtenant structures. An agreement providing for the maintenance of the signs or structures in a recordable and satisfactory recordable form satisfactory to the city shall be furnished to the city prior to the installation of the sign or structures.
Here's where I got a problem.
There you go.
Because associations, homeowner associations, they come and go. They come out with the big idea, we're going to have this, and everybody's going to be involved, and then they dissipate. They're gone. Now, who's going to maintain that area? Here, it's been the city, like Fraser Meadows, I think. Sometimes they would have to do all that. Now you're adding work to the city to maintain that median completely, and this can just get carried away and just be left alone, and here you got a nice subdivision. Some of the people go out themselves. I mean, I've seen every different thing. I see people just
Our
from the
sub, they're
neighborhood.
not doing this.
And people love doing the gardening, and they go out there and they take pride in their entrance. But it doesn't cover our butts here with an association to being responsible, because that association could be gone. Now who bears the responsibility?
An example of that, my brother-in-law was in an association, and they got into a lawsuit with one of the people, and they blew all their money, and all of a sudden the association went away, and nothing got done, you know, to what they were supposed to do then. 'Cause all the money went to the lawyers. Alyssa, all the money went.
Very quiet over here, Mr. Farina.
So how do we address
we get it,
that?
right?
How, you know,
What's the backup? You know, if there's no association,
Well, could you put a clause in there that if there is an association that is responsible, they must create a trust or a fund for the maintenance?
my question, Ms. Erickson, is I don't think as homeowners associations go through the city, they go through the county,
wow.
right?
They may, yeah. I think this is going to take a little bit of creative wordsmithing and thinking about all the different angles. These are all great points that have been brought up. I know in some of our other maintenance sort of agreements, we usually make it binding upon, you know, any successors or assigns, but if there's no association, how do we get there? So that's definitely, I'll make a note, because that's a great points brought up by the commission.
Are we done? Or did you have a note in red? I don't know. Is there a note, do you follow up on your notes there, Ms. Sierra?
Yeah, I can read it. It's just kind of detailing what the existing provisions allow, which are no more than 2 signs for entrance identification, and has to be the subdivision name only. The sign can't exceed 24 square feet, and no more than 1 sign may be placed on each side of an entranceway or in an entrance road median. Those are the main takeaways, so we give them an extra square foot in our new one.
Okay, and we're done?
And that will take us to the end of this month's sign discussion, so see you, tune in next month for another.
Okay. I will, note, up to this point, we had no one in the audience. I didn't open up the floor to any comments, but I will now. We do have a gentleman in the audience. Would you like to have any comments on the sign ordinance, sir? Okay, please come up, identify yourself by name and your address, and let us know what your comments and concerns are.
My name is Paul Salufo, 31640 Ciro Avenue. My concern is that when I was on city council, at the time, we had a lot of banner signs in the city, flag signs. When I say flag signs, I'm talking about the post with the little thing blowing in the blowing in the air. And it got kind of out of control. So I looked into how they were allowed to put those up, and I was told at the time that it was a permit that was issued by the city manager, and upon looking into it further, it had to be, it could not be re-upped. In other words, it was only, I believe it was 60 or 90 days. I forget exactly what it was. But my point is that it seems as though in our city, and this is not a slight on the city or any members of this commission or anything, but it seems as though we tend to let those be put in place and let them stay there till they degrade to the point where you can't hardly even read what's on the sign. And sometimes they're placed very, very close to the roadside, you know, to the roadway. And it was always a real concern of mine because I do firmly believe that the value of a community is the laws and ordinances that we uphold, first of all, but that we require to be a member of that community. And it's not being, I appreciate Commissioner Barr's remarks, it's not being anti-business on something like this. This is just good housekeeping, that type of thing. And I don't know, I missed some of this because I was at home watching it, and then I said, I'm going to go up there and, because I've been wanting to talk about this for a long time.
Good. I'm
It's
glad you
it's
came.
very it's very bothersome to, I don't want to say bothersome, but it's very annoying when you drive down the street and you see these things flopping in the breeze and they're half gone, you know, it's just a bad situation, you know. So I don't know whether that still exists, that it is a permit that has to be granted by the city manager. I don't know if there's still a allowable time limit that they can do that. I do believe it's still a one-time issue type thing, so I don't know. I appreciate information on that.
Commissioner Farina, let me ask our city planner, Ms. Sarah, if you can backtrack to the banners and let us know what we have incorporated recently. And I'll give you some time, and I'll let Commissioner Farina comment here.
They're really temporary signs,
Right.
what you're talking about.
Right, if I could just add one more thing to that. It was about temporary signs because we had a business come in, he had an A-frame type sign, and he was, he was gonna leave it there forever and ever and ever. He didn't really want to do anything with it, and it wasn't a permanent sign. He did get a permit, but he had extended past that permit allowable time limit, and it stayed there. So, yeah, if we can, I should say, not we, but you guys can look into that and address some of those concerns. I think it's a good thing.
Okay, we appreciate your comments.
Thank you.
And Ms. Sarah, do you have any follow-up comments? You can sit there still, Mr. Salufo, if you'd like.
The ordinance specifies in the community business district that banners and other appropriate displays are permitted only for commercial and institutional activities approved by the city manager.
Okay.
In general, the temporary signs, in the general provisions, it does say a limited number of project signs of temporary duration. I think those are supposed to be more development type, not event type signs. It does mention those, but they, not to exceed 64 square feet, may also be permitted subject to the approval by the ZBA and a 6-month time period. Again, I don't think they're temporary, but I don't think those are what it's referring to.
I don't even think they apply anymore. There's a gas station at Groesbeck and Utica. Must have 4 of these freestanding banners.
Exactly what you're talking
For
about.
a long time. I haven't been by there recently, but I had noticed it before that.
So they should be non-existent, is what we're saying. They've been there way too long. They're not really,
I believe we did address kind of banners and these temporary type grand opening signs in the previous, I don't have that quite on hand.
that's okay, I understand. Yeah, it's kind of caught you off guard. Mr. Salufo, I'm going to ask you, if we didn't address it right now, we're going to give our
Oh,
city
absolutely.
planner and our attorney time to address that. If you can communicate with the administration also, so they can understand your concern, so we can kind of, get to the nitty-gritty of
Right.
it, we'll take care of it.
Yeah, good.
Okay.
All right, thank you so much.
I can?
Yeah.
Let me, yeah, question, Mr. Salufo. Paul, you slipped and you said "we" in there about, like you were part of this. So I want you aware of that we have an open seat on this board.
Think about it.
I appreciate that very much. It's just, can I say just one more thing?
Yes, sure.
What I thought was interesting is that sometimes a city or municipality has laws and ordinances in place, but either maybe some members of the enforcement area or some members of the community don't realize that those are there. And it just kind of, and then sometimes even new ones are actually being made, and the old ones are kind of being lost, but actually it was covered. So many times you get into some of that stuff and you look at it and say, well, wait a minute, it was actually addressed here, you know? So I think it's really, I find it very interesting. I know a lot of people would say sign it. I think it's very interesting, and I think that it's something that sets communities apart when they require certain things. Some people say it's like unneeded restrictions. It's not really. What it is they want everybody to be kind of in line with each other so that the businesses and everything look very similar. And I understand a lot of that.
Aesthetically pleasing, yes.
Yes,
We want it to
right.
be clean cut.
Aesthetically correct, so to speak, yeah.
right.
So I also want to say I appreciate this board and zoning as well, because I do think they're the cornerstone of a well-run community, so.
We appreciate that. We need to, our code enforcement needs to be built up a little bit more,
Right.
I think, to take care of some of the issues throughout the city.
Right.
Mr. Salufo, we also have 2 vacancies on the zoning board of appeals that deal with signs.
I appreciate that,
Okay.
thank you.
But I do know what you mean, because even the code enforcement too, probably the same thing. You drive by this so many times it becomes, it's just there, and you forget, because you've seen it every day for the past year, and some of these things get carried away.
Right.
And it just,
And
Somebody
in
needs-
checking in that ordinance back then when I was on council, they actually had to have the permit in an area of the business.
Posted.
That is, yeah, posted. And so I thought that was pretty well, all of that was pretty well thought out, except there was nobody there to say, hey, you're on your 120th day now, you're on your 300th day now of this, that type of thing, so.
Do we post permits on signs now? Do you know, Mr. Warren?
well, they're supposed to be on the site. I don't, when you say,
Just temporary.
do we, I don't,
Okay. There again, right? It's kind of fallen to the wayside.
yeah, that's a Michigan, it's in the Michigan Building Code that it needs to be posted, but,
That's actually where I saw it when I was looking into that, so.
yeah, it's just, things get carried away, people don't, and nobody, it's one of those little laws that nobody really enforces, it seems. You can enforce a lot of stuff that's there, but it's a matter of
That's why we're
having people that do that.
That's why we're trying to clean up the language. That's why we ask some questions. What is enforceable,
Right.
I do have a question for Lauren, though. It just hit my mind. Have we addressed the LED lights around the windows in this? I thought we were.
Yeah,
going
back
to,
in
but
the beginning. it
Yeah,
was,
okay, all right.
Thank you, Mr.
Thanks, Paul.
Salufo, for running up here. You're welcome to stay.
Paul, I have something I want you to read afterwards.
Okay, any more comments, discussion? We'll move on. Okay, we ready? We're going to go to agenda item number 8, public communication on non-agenda items. I am not aware of any.
Gotta open public hearing.
Open the public comments? No? Is that what you, open the floor to public comments on agenda item 8? Mr. Salufo, do you have anything? Okay. Agenda 9, monthly report, January 2024. Do you want to address it or just ask for comments or discussion?
The first part might be between Commissioner Farina and the attorney,
Okay.
but it was extended to February 16th.
Do you want me to say it?
Go for it, Mr. Farina.
Look, we're talking about Hockeyland.
Yeah, I apologize.
Big boy,
Yeah, Big
that's
Boy
okay.
Hockeyland.
And they have been extended to February 16th, but also the drive-through is not operating.
They are not allowed to use it unless, and correct me if I'm wrong, Ms. Erickson, that they get special land use approval for the March Planning Commission meeting.
And have we received an application? But go ahead, Ms. Erickson.
Sure, yeah, so I may have touched on it last time, but the special approval land use, as this commission I'm sure is aware, had the same conditions that the site plan had. Obviously, the applicant came before the planning commission in October, I believe, and modified those conditions. So essentially, as part of their special approval land use for the drive-through, they would have either had to modify those conditions to mirror their site plan, or comply with them, or simply abandon the drive-through use. It's my understanding that they have elected to seek a modification, and it's possible that they will be on the March Planning Commission meeting.
Okay, okay. Thank,
Is there any target in mind for them to complete?
In terms of the outstanding documents? So
What is still outstanding?
there are 2 engineering documents that we have not received. I was in contact with their attorney yesterday and provided our revisions on the cross-access easement. But they have to have those engineering documents back to us by February 16th. And then there's some other miscellaneous in terms of recording and providing us a copy.
and that's what you're referring to on the easements, cross.
Correct, yes.
So how many more things got done that were not done by the last deadline?
Which would, you referring to middle of January, I think was the last deadline?
Certainly, yes.
I would say probably 3 things, I would say, in between the last, middle of January to now.
So they're making a good faith effort
Correct.
to complete the items.
Good.
Okay.
And also, since you're doing the monthly report, can you give us an update on sheets?
Okay, thank you.
Real quick, I'll throw it in here. The auto shop at 3100 Grossbeck did withdraw.
You probably gave them a challenge, I think.
They got the easy part. Maybe something fell through. Who knows? But yeah. So Sheets has not. I do not believe they've initiated the process of getting the conditional rezoning agreement with the attorney, but they do still intend to come back. I believe they're still they're kind of talking internally right now to figure out a game plan, but I believe the intention is to come back before City Council, and there, I believe, will be another public hearing at that City Council.
But at this point, they have not initiated.
There's nothing on the
Agreement.
calendar now.
Okay, okay. Thank you, Ms. Sayre. Any comments, discussion? Open up the floor for comments on our report. Mr. Slufo, did you read everything on the agenda this evening? Okay. Any comments on this item? Any questions?
I do have a comment about the sheets.
Well, come forward.
Although I don't know the process, Paul Salufo, 316400 Avenue. I don't know the process exactly how it should go, although I do know how it was done when I was in council and involved. Generally speaking, a business like Sheets would come in front of planning. They would present their case of what they want to do with the proposed property or whatever. And at that time, if it had to have some kind of rezoning or whatever, the people around were notified. And that's exactly what happened this last time.
Correct.
What I would hope would not happen, if in fact they do decide to come back in front of the city council, that we would look, because I'm looking at that as the city council at that point is acting as a political zoning board, which is what that would be, because they're going to change, but they're going to go ahead and authorize, if they do authorize it. And my point being this is what I'm trying to get at. It's a little frustrating for me to say because I wasn't thinking about this, but is that would those people, would the council, if they have a hearing or a meeting relative to doing whatever they decide they're going to do, if Sheets does decide to come back, wouldn't the people have to be notified again?
Okay. Let me give you my thoughts on that, and then I'll ask the city attorney to either agree or disagree with me, okay? Should Sheets come back with an application in front of the city council for a conditional rezoning, I understood that the city council will be holding a public hearing. If the public hearing is scheduled, yes, it'll be notified and posted. If there is no public hearing, then it would not be notified or posted. But during that city council meeting, if you know the items on the agenda, the floor will be open to comments.
Right. And that was one of my questions, even the night of January 3rd, I believe it was, is that the people will be notified. And,
Only if there is a public hearing.
right, and I posed the question to Cindy, and I think her name is Cindy.
Our city clerk, Cindy
Yes.
Grenia, yes,
She said they would be notified, so.
yes.
You're expecting a mailing? Or
The
it could be put
notification
on a
only
roll
goes
call?
within 300 feet of the proposed development. That notification's only within 300 feet radius of that proposed development. So whether you're included in that 300-foot radius, I don't know, Mr. Saluf.
No, I'm not, but I think I think to notify these people, whether, I think by mail would actually be the way to do it if I was kind of calling the shots on that, because I think you have to be upfront and obvious on all
Transparent.
efforts. Yeah, I know,
Transparent.
you guys. no
Right,
question.
but that public hearing, no
Right.
matter what proposed development, if there is a public hearing, the mailing notification only goes with a 300-foot.
Oh, no, I understand that.
Okay.
Yes, I understand that, yes.
Okay. All right. Okay.
That's
Any
it.
other comments?
No, that's it.
Do you understand the procedure? You can always call me, I can.
I do understand the procedure, but I did find it interesting that now the council now will be acting as a zoning board. And I understand a lot of that and how that can work, but I was under the impression they would have to go in front of zoning next. And then whatever zoning, then they could appeal it probably to council, whatever.
With the conditional rezoning, the applicant is the person, they come in with offers, the amenities that they want to offer. So that particular conditional rezoning, the components to it are the special land use exceptions and the sign ordinance exceptions. So that's inclusive of the whole package. I hope I'm explaining this okay, Ms.
I'm not stepping in for good reason. You're
Okay.
doing great.
All right. So yes, it's, the city council's not going to say, well, you don't meet the criteria for special land uses, or you don't meet the criteria for the sign variances. That's not what they're going to address. They're going to address the conditional rezoning as a whole,
I see.
and those components are incorporated.
Do that. Okay.
Okay.
All right, good. Thank you.
You're welcome, sir. All right, we have any other discussion or comments on the zoning report? Okay, we're going to go to agenda item 10, zoning board of appeals member liaison report.
We were to have a meeting, and the only thing on the agenda was the interview of a candidate for the ZBA, and she could not make the meeting, so the meeting was canceled, and we will be reviewing her status at our next meeting, which is going to be in March.
But that's good. You got a candidate.
Yep.
That's great. Good
That
news.
came out of the planning commission meeting last time.
Good.
Okay. Agenda item number 11, commissioners' comments and items of interest and concern. Before I, ask everyone if they have any comments, let's go to two of the items that you brought to our attention, Ms. Sear. One is the signage notifications for proposed developments, and the other one is the city council requirements or for public hearing when it comes to conditional rezonings, or any rezoning.
Yeah, so these items were brought forward mainly from the Sheets meeting, and they're just items that Chair Zarnicki and many of you have kind of expressed concern over. So the purpose of this is, again, to provide background, and then hopefully for the board to provide a directive for planning and the city attorney to come with some draft language for potential zoning text amendments. So the first one is on-site notice for public hearings. The attorneys did review it, the Michigan Zoning Enabling Act, and determined that it's neither authorized nor prohibited to add signage as a required form. Fraser's current zoning ordinance does not require on-site signage for projects requiring a public hearing. And then also included is a table with neighboring communities. Of course, they all require the newspaper circulation and the mail. And only one requires on-site signage, and this is only for rezoning or changes in zoning district, and that is Warren. Also, a couple other things to note is that While it would increase transparency, it would also impose an additional fee on applicants. Another consideration would be maybe only doing it for rezoning type projects, such as, similar to how Warren does it.
Those would be my comments, is to do it for rezonings, conditional rezonings, maybe a planned unit development, anything, any development that requires a public hearing. That's my thoughts, and I agree, the positive aspect is it does increase transparency for the residents. The negative is it's an additional fee for the applicant. It's also an additional fee for the city to create the signs and to post them and remove them.
So when you say for public hearing, special land use is also,
Special land use also.
so you would include that in
I
there?
I would personally. That's just my thoughts. Thank you, Ms. Sarah.
But it all comes back to the sign. When we did it, we always did it. We'd post on the site, but it was always this size. We just put it in a clear thing and made it weatherproof and put it on a stick. And just put
On
it
the property, on a
on the
stick.
property. And
So the sign was.
And I do see, yes, there's others, and it might not be in their ordinances, but you still see a lot of those other cities put up, and some of them do make a sign.
Big
And it's a
signs.
big sign, and yeah, there's an expense. There was no expense for me to take one of them. All it was the same 300-foot notice that we sent out and put it on that stick and protected it from the weather. And you'd hope that somebody, if there's a sidewalk in front, they see it then, but we always thought it was a requirement back then of the Zoning Enabling Act, but apparently it's.
It may have been under the prior zoning
prior.
enabling act,
It
but
probably was, and then we
Yeah.
just continued doing it. But, I mean, does it have to be in there? It could just be something that we just do. I don't know.
It wasn't
not
an
be in
exorbitant cost to the city, though. if
To
you
me,
did
it was nothing. I went and did it.
Okay.
So I was on the road, I'd go there, I'd just make this thing up, put it on a stick, and pound it in the ground right there, and it was there on site at least. But, yeah, you're driving by, you'll never know. You know?
No,
The
visual,
only way was like the big ones, which you've seen.
right.
So that is a big added expense. And
That is,
don't-
I understand that. That
Yeah.
is.
So it becomes a thing like, what do you want to do, I guess? Do we want to, it is the transparency thing and letting everybody know.
You know,
But-
by the time I get my local newspaper, the public hearing's already done.
It's all done.
It's all
Yeah, if you're reading the Chronicle.
So
or
I
something.
don't get informed, right.
No. Yeah, we don't know. And
That's just my.
it's always too late then, too, so.
Correct.
So throw that out, that's all.
Just throwing it out. Any other comments about it? Because I don't know how to, if we're not in agreement.
I think it's a good idea. When you change zoning, I mean, everybody should be
We should be
notified.
aware of it.
And a special land use especially.
I agree.
Now, are we talking about the sign that Commissioner Warnock, like a paper-sized, or are we talking like a larger?
sandwich board almost.
Yeah.
I know that in Sterling Heights, for use variances, they put out like big sandwich boards.
Yeah.
Which obviously I think is what Mr. Warnock is referring to, is adding some costs.
It
so-
does add cost, yes. And again, I don't want to stop people from coming into Fraser, but it is at a cost, I know.
And do they put that cost into the,
Into
the applicant's
application. Well,
price,
sure they do,
yeah.
but not making the sign or anything. It's not making, that's going to be our DPW department, I assume. Making.
there was always a problem with costs. For all the times, there were, we'd have a zoning, come to the ZBA, and it would cost $100. Well, you figure out just the time we put in as administration just to get together the 300-foot notices, send everything out, the mail, everything. It was $500 probably by the time we were done, not counting probably the time of who you pay. You're paying them regular time. So we'd keep getting the fees up, but we tried, I think, council always kind of kept it like, okay, we give something from the city still, so we keep it down, even though I'd keep saying, well, here's the cost. I kind of figured out a cost thing, and it was maybe $400 or $500, and it's okay, we jumped it up to 200 then. It's like, where do you draw a line? So I'm wondering, do they have an exact fee, these other cities? Do they do, because it is a big expense, but they're paying for it. The applicant's paying for it, not the city. And that's where it shouldn't be the city paying for it. If they really want it, then they should put that sign up if we want to go to that extent. But I don't know that we need to go to that big.
I agree, I don't know if we need to go that big either.
Right.
But if you see a little sign, you're only going to see it if you walk by.
Exactly.
I-
A real estate sign, type sign that you know, put in the ground that's this big by this big.
And you don't want it half, where somebody just drew it up.
Yeah.
That's why they get professional signs made up. Yeah, you probably can get those pretty cheap now some way, like a decal type thing, and put it on a board or something, but I don't know, it's one of those things.
We can try to ask DPW before the next meeting about what their cost estimate would be. I'll also note that the required newspaper hearings also, sometimes they'll run up to $1,000. They've
I know.
also are
Very
quite
expensive.
burdened as
Yeah.
well.
Yeah, very expensive.
Yeah, especially when before we'd do the Macomb Daily, and then we finally said, whoa, what are we doing this and putting it into the whole county? When all we got to do is, the only people concerned was the community. So we'd put it in the Chronicle, which was still Clinton Township Fraser or Roseville Fraser. And
And
it's
you
like,
still don't see it in time
and you
for
still
the
don't see it in time, so.
application, no.
I know.
Ms. Sarah, I appreciate, maybe you're looking into it. I can make a connection with the city of Troy and see how much the signage costs there, and I know they charge the applicant, so, but I'll do some legwork on that too.
Yeah, I would likely think it would be maybe an escrow or something.
Yes, yeah, we do collect escrows now for our applications, do we not?
We do.
Yes, okay, so yeah, it just added to the escrow,
Yeah.
okay. All right.
The next item is regarding public hearings at City Council for rezonings. And so currently, as the ordinance is written, Planning Commission is allowed to, City Council may hold a public hearing, but it doesn't have to. Again, looking at some peer communities, none of the surrounding ones actually require, although both Fraser and Warren allow at the city council or township board level. Again, some items to note: it would increase transparency, increase public input. It also, I guess, should be noted that, as Chair Zarnicki said, that applicants are still allowed to comment on agenda items at city council. There's also likely an added fee, as we just discussed, newspaper circulation. So I guess when considering holding a public hearing at city council, there's a couple metrics that also might be practical, such as by zoning district, so maybe only certain zoning districts require a public hearing, by rezoning type, or by planning commission recommendation. Perhaps planning commission, when they forward on the recommendation, could also include if they think a public hearing at city council would be necessary. Just some potential items.
Any comments? Discussion?
Alyssa?
Alyssa?
Anybody else? Any other planning commissions do it that way? That you know?
Not that I know of. I know in the other communities that I regularly attend planning commission meetings for, it's set up just like Fraser's ordinances are, with just one public hearing required at planning commission.
I guess it's my background, because City of Troy,
They require both.
yes, yes. I know I brought the subject up, but I like that third bullet. And if I had known we could have done that at the last January meeting, I would say, okay. I would ask for a resolution, but we also make it conditioned on the city council holding a public hearing. So I think maybe it goes, case by case, is what I'm thinking. That's just my thoughts. when we have a crowd full of people like we did in January, I think city council should also make it a point to listen to our residents.
Yeah, I will note that when drafting this, planning did not get input from legal, so we will follow up on, on potential language and if that's, acceptable.
Right, but that's my opinion. I don't know about my cohorts here. I don't know how they
No, I
feel.
agree.
I agree.
I agree.
All right, that's it for me. Thank you.
You're welcome. And Mr. Salufo, I'll open this up for comments from you. Do you have any comments on transparency with, public hearings, signage on the development, and/or how public hearings might be required by city council?
I would like to
Come back up.
I would like to think that all parties concerned would want to be as upfront and obvious on the potential of a decision. And I would think that city council, as well as all the boards, would want the input to help make those decisions for the good of the community. So I think it's a good thing that these people may be, from what I can gather, they may be notified of a possible decision, whether it be through the council or whatever. But I think it's a good thing to follow up with that. I think it's a good thing. I think it shows good faith from the city to the residents, and I think we all need to be good neighbors, so I think that's a good thing.
I agree. Okay, thank you, Mr. Salufo. I have confidence the city council will open up the floor to comments also, should the Sheets application come forward. Okay, we're going to go to agenda item number, well, no, we're going to continue with 11, and I'm going to ask Ms. Barr, do you have any comments? Anything you want to share with the board?
No, not at this time.
Okay, Commissioner Warnick?
Yes, I was going through the ordinance updates that you sent and that, and I like that idea with, we were talking about the permeability and the paved surfaces and that, and it got me thinking of something just while at the beginning of the meeting here. What we used to do on the planning commission is bring in people, business manufacturers, to talk about their product. And Frank will probably remember, we had one where the paint for black, because the biggest problem was having when you painted black where you couldn't do it, but they'd come out with some good products that would adhere, and we brought somebody in from Sherwin-Williams, and they actually gave a presentation on this paint. And we actually started, as the building department, making that a prerequisite if they were going to paint existing black and do something like a different color. So I was thinking, and I would have no problem going and trying to get somebody for like these, like Frank brought up with the mats for permeability for parking, to having a parcel on grass and put these mats like maybe, and then put grass on them, or something that you can still have the permeability so that water will drain, and start using some of these areas like the churches do with their festival and that, and park on the grass, and still, it's the grass still, but it ends up being a stronger surface that still allows all the water to drain through. I think we get one of those manufacturers and let them talk to us or present. I think it's great to have ideas to give to new businesses that come here, and give them different things, or here they planned on something, we can say, hey, did you ever look at this product? And it could be a cost saving to them, a big cost saving, but it also gets us to a point of where we don't have that impervious surface, too much impervious surface. And so I just thought I'd bring that up. If anybody else maybe comes up with something, or we start talking and see something, that threw that out to me. I was glad you put it in there. And now I thought, well, hey, why don't we get somebody, a manufacturer out here to talk to us about it or do? So there's nothing wrong with us having somebody come and present to us things like that. So if you guys are up to, I know we used to do it in the past.
I went up to Traverse City, and my sister took us to this little craft place, in their parking lot, they had, it wasn't a cinder block, but it looked like a cinder block stood on edge. And then grass was, it wasn't pea gravel in there, it was grass in there. And so it withstood the tires because they were close together, but there was also permeability, so the water went through, and we didn't create more trespass on somebody else's property with shedding water off, so. I'm with you, Randy. I think that'd be excellent, to look at.
That was it.
That's okay. You want to add it to their work plan, or you want to kind of incorporate that into our 2024 work plan with the.
Yeah, I think that, the best way is to learn about this stuff.
I agree.
We need to be up on the cutting edge. So there's nothing wrong with having somebody present that stuff to us.
Okay. Appreciate your comments. Anything, that's it?
Yeah.
Commissioner Kyle?
Nothing at this time.
Commissioner Farina?
Oh, yes. It is fish time in the neighborhood. St. Malachi will be putting on fish fries Good Friday and Ash Wednesday, and every Friday through Lent. Great fish, good company, come by. That's all I have.
Okay. And Commissioner Meyer? No. Oh, don't you want to make an announcement, what you're going to do?
Sure.
Okay, you go forward.
Okay. I'm going to go to the Tacoma County program for zoning for the next 7 weeks.
Citizen planner.
Citizen planners for the next 7 weeks.
An MSU extension
Yes.
program? Yeah.
Yes.
Good, very good.
Yes. I kind of recruited her because she's our newest member.
Nice.
Yeah. You'll, it's a learning experience, very worthwhile.
Yeah.
So thank you for doing that with us, for the board. Anything else, then, Commissioner? No? Ms. Warren, you want to tell us about your new addition and anything else you might want to share?
No, I do have a comment regarding nonconformities we were talking about. City of Troy, about 6 years ago, hired an intern, myself, to go through every square foot of their city and take photos of every single permitted sign, and non-permitted sign, but non-conforming signs is what their goal was. I took a laser camera, took photos of every single thousands of signs, and it went into a GIS system. And that was how they're going to continue to track their signage and possibly get rid of non-conforming signs down the road. Came up with their large 200 square foot electronic billboards when they had all of these pop up. So just something to think about, that there are tools and gadgets out there.
Yes.
Obviously there's a cost, but there are things out there to track. It takes a while. Obviously Troy is a lot larger than Fraser.
A little bigger than our Foursquare.
A little bigger. But there are things out there that you guys can do to keep track of those.
Thank you for bringing that to our attention.
Yes. And that's all.
Okay. Ms. Sarah, do you have anything?
Just a reminder that I believe Monday, March 11th is when we're targeting that joint training still.
Do we have a time for it yet?
I do not believe we have a time or location yet, but I believe Ms. Greenia will be following up on that.
Okay, all right. Ms. Erickson, anything?
Nothing this evening.
Okay. I think on my list of things, I think everything's been covered. Yep, that's it. I have nothing either. So we will go to agenda item number 12, adjournment. I'll entertain a motion to adjourn.
Make a motion to adjourn.
And support?
Support.
Okay. It's been moved by Commissioner Kyle and support by Commissioner Meyer to adjourn the meeting. All those in favor say aye.
Aye.
Hey.
Any nays? Motion carries.